Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's true with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
Hey all, today we are talking about a tragic case out of Michigan that actually happened last year, and I'm just finding out about this recently. I'm late to the game, I know, so sue me. If you know, you know. But a 5-year-old child is dead after his mom took him to a clinic for hyperbaric oxygen therapy. That poor boy, his poor family. But now 4 people are charged, and a lot of people are asking questions, mainly me, because of my background, about why he was going at 5 years old to hyperbaric therapy. Also, the promises that were made about this. So, hyperbaric oxygen is FDA approved. And this is where we sit in this gray area because it is FDA approved for some things. However, it is not FDA approved for other uses, including what is being alleged in this case. So somewhere in the middle, you have families who are desperate for treatment, you have FDA guidelines, and you have clinics who may or may not be legitimate and safe. And this is where my major issue with this all comes in, is not just accountability for the boy's family, but the long-term safety and a larger topic that we've kind of been discussing on this channel and my other channel, which the QR code for that other channel is right there. Please like and subscribe to that channel. I would greatly appreciate it. But where do we trust our healthcare system and alternate uses for therapies and people trying to get help? And where are people being taken advantage of? So with that, we're going to break down the case itself. We're going to listen to the press conference that was done by the Attorney General. We're going to watch a hearing of the CEO of the facility that is being charged. Also, we are going to look at FDA regulations, guidelines, what HBO actually is, what it's approved for. And I will be completely honest with you, I had many patients over my 6 years of inpatient therapy or working in inpatient care that we're going to daily HBO, and I am not convinced that it actually works for anything outside of 3 to 4 different, issues. But that is just my personal opinion. So I am a HBO skeptic from the very beginning. I will lay that out on the line right away. I'm an HBO skeptic, even of things that it is FDA approved for. With that being said, we are going to get into it right now and protect your mental health with this one, because this is a 5-year-old boy, and an adorable one at that. So we are, if this is too much for you, I understand, and I will see you on the next one. However, I am going to say hi to chat. And thanks for bearing with me. I'm a half an hour later than I wanted to be. Scheduling a live at 2:30 when you don't get done training your people until 1:45 is not really a good idea. But Heidel, thanks for being my super mod and adapting to me being late. I should have never scheduled it when I did. Jeffrey, like number 2. I think Heidel beat me this time. She did. Wisconsin, how are you? And Unhung Hero, thank you for the 20 gifted Squid Purple memberships. I appreciate you so very, very much. I hope you and the missus are doing well. Rick Reed, how are you? Roy, I hope you and the missus are also doing well. Give her a hug for me. Mr. Landfill, how are you? Yeah, if that was in Michigan, I know where that place is. It is in Michigan. It is. Malon's green. I just saw Malin, you're green. Andrea, how are you? And we're going to get through this together. Flash fan, good to see you. And Nick, you saved me from the Cletus Convict live stream. It's taking over my life. I have no idea what that is, or I'm completely slow and it went over my head. Jeff, how are you? I hope you are doing well as well. Tammy, good to see you. Can't stay. Mother's Day event here. Hit the like though and enjoy the stream. Yes. How's our favorite Southern calamari? Melting currently. Bruce Maskin got turned green. I have not looked at actually who got all turned green. I will have to that's part of the reason I was a little late was it's one of those situations of hey, I'm here, but the subject matter, I am weak. I get that. Cynthia, how are you? And I'm sorry if I miss you. I don't mean to. DR Most, Snipe, good to see you. It's night somewhere. I saw that flash fan. And then Unhung Hero, thanks for the $2 super chat. I don't watch HBO either. Yes, and if you do hear me refer to it as HBO, I am very, very sorry. HBO is the medical documentation terminology for hyperbaric oxygen therapy. I just I write in medical terms all the time, and I still use medical terminology, even though I have not worked in a clinic in a few years, and I will refer to it. I am not trying to speak down to anybody by doing it. It is just it's ingrained in my brain, and nothing will ever change it, unfortunately. So we are going to hey, Boosh, good to see you. All right, we are going to get straight into this with the press conference. And I am sort of prepared today-ish. So this is the press conference from the Attorney General. I will speed it up a little bit just because it is a 20-minute press conference, but she goes into what it's about and more than reading an article would. Hey, it's Mother's Day, a made-up holiday like Juneteenth. Well, I got flowers and cherries, berries from my dad today. So if you see Papa Squid in the chat at all, tell him thank you from me. An extra thank you. All right. Hopefully y'all can hear this.
I'm announcing criminal charges against 4 individuals in connection to the tragic death of a 5-year-old patient inside a hyperbaric chamber at the Oxford Center in Troy on January 31st. Let me first say at the outset, criminal charges are merely allegations and all defendants are presumed innocent unless and until proven guilty in a court of law. Due to many failures by men and women who would call themselves medical professionals and wanton or willful disregard for the likelihood that their actions would cause the death of a patient.
All right, volume, let me try to unshare it and share it again because I had it set up and I shared it before the stream. So that might actually me actually being prepared is not you know, me trying to be prepared and all of that stuff is stop screen. Let's try to reshare it again because maybe sharing it before the stream started was the problem because Lord knows. Let's try this. See if it works now.
5-year-old Thomas Cooper was killed when a fire erupted inside the pressurized, pure oxygen environment inside the chamber. A single spark, it appears, ignited into a fully involved fire that claimed Thomas's life within seconds. Fires inside a hyperbaric chamber are considered a terminal event. Every such fire is almost certainly fatal, and this is why many procedures and essential safety practices have been developed to keep a fire from ever occurring. The investigation into this tragedy has revealed how the Oxford Center in Troy and several of its key decision makers held safety among their lowest considerations in their hyperbaric treatment practice. Yesterday, 4 people were arrested in connection with the tragic killing of Thomas Cooper. My office has filed charges against the first 3 defendants with second-degree murder. Those charged are the owner of the Oxford Center, Tamala Peterson, the primary management assistant at the facility, Gary Markin, and the Oxford Center's safety manager, Jeffrey Mosteller. Each of those have been charged with alternative counts of involuntary manslaughter, meaning that a jury will be able to decide which charge properly befits their conduct. My office is confident that second-degree murder charges are appropriate for these individuals. This offense requires that the prosecution prove the defendant or defendants acted either with intent to kill or commit great harm, or, as specifically articulated in the law, to have acted in wanton and willful disregard of the likelihood that the natural tendency of said act would result in death. The jury instruction states it even more simply. To prove this charge, a prosecutor must prove that the defendant caused the death, that the death was not justified or excused, and that the defendant knowingly created a very high risk of death or great bodily harm, knowing that death or harm would be the likely result of their actions.
Which will bring up the maintenance record of the facility and of those machines, because having worked in a very large medical center with a lot of hyperbaric chambers, like we sent hundreds of patients to HBO every day. We in fact had a few people, there was a house fire, and I remember hearing that the children that were in the fire were being brought to our hyperbaric chambers because the Children's Hospital of Wisconsin did not have hyperbaric chambers at the time. I don't know if they do now, but at the time they did not. So they were brought to our facility to use our hyperbaric chambers, which is interesting because the Children's Hospital of Wisconsin is attached to Freighter, which is a level 1 trauma center. We had more facilities than they did. It's just an interesting conundrum. However, it will bring up not so much the user of it, but the maintenance records and how much did the CEO know? Did they cut corners? These are all things that come up in my brain when I hear about a problem. Because the nurse or whoever, the tech who was using it, may be responsible for a daily check, but at the end of the day is not generally responsible for doing maintenance on it or knowing what the routine maintenance is every 7 days, 14 days, whatever the protocols are. Generally the tech who's using it is not proficient in what those are, but maybe should know if they were done. It's all about what people knew, which will be interesting to find out.
We intend to demonstrate in court a series of actions undertaken by these defendants that satisfy these charges and tragically led to this child's death. Should a jury decide the state failed to meet the standard, they will have at their disposal the alternative charge of manslaughter. And to convict on this charge, the jury need only determine that the prosecution proved the defendant's actions caused the death of Thomas Cooper, that the death was not justified, and that in performing the acts that caused Thomas Cooper's death, the defendant acted in a grossly negligent manner. Additionally, we've also charged Alita Moffett, the operator of the hyperbaric chamber at the time the device incinerated young Thomas Cooper, who faces 1 count of involuntary manslaughter and 1 count of intentionally placing false information on a medical record as a medical provider. In the immediate aftermath of the
That's going to be an interesting one. I don't know about the manslaughter. I don't know if they'll be able to prove that. That'll be an interesting one to me. However, I'm curious about the medical records from a healthcare provider's position. I am so curious about what that is about. This is why on this channel I've started covering topics just a little bit differently. Not so much based on the drama or anything like that, but based on my history as an OTA, my history as a lymphedema therapist, working with patients in ICUs, inpatient acute care floors, on inpatient rehab. And with that, I have a lot of familiarity with a lot of this. And not to say that my hospital was great, because Lori can tell you that it's not. However, we all have our fair share of problems. I know that certain protocols are supposed to be done, and from a reputable US World and News best hospital, whatever you want to take that with a grain of salt. However, with that being said, I know how things are supposed to operate from an operational standpoint, and some things in this just seem hinky to me.
explosion at the Oxford Center in Troy. Troy Fire, Police, and Emergency Medical Services deployed to the scene of the explosion, and the Troy Police Department began an investigation into what occurred. My office was quickly in touch with the Troy Police to offer assistance. We made available to them our special investigative agents and whatever other resources they requested. And through this investigation, remained at all times under the leadership of Troy Police. And they've completed their criminal investigation and submitted their report and findings to our office, where our state prosecutors conducted a review for any and all potential criminal charges. In the course of this investigation, experts on hyperbaric chamber and treatments were consulted extensively, and some horrifying and simple conclusions were reached. Obviously, there will be much we cannot yet fully discuss or disclose until such items are entered into discovery or as evidence, but suffice it to say for now that the Oxford Center routinely operated sensitive and lethally dangerous hyperbaric chambers beyond their expected service lifetime and in complete disregard of vital safety measures and practices considered essential by medical and technical professionals. Hyperbaric.
And that right there is why the CEO, I believe, is being charged, because you operated machines past their life expectancy, and instead of paying, yes, they're expensive. Instead of paying for new ones, you ran them past their life expectancy, and then something like this happened. That right there is the negligence aspect.
Hyperbaric chambers are not new technology, and there are, in fact, many national and international safety standards developed to ensure patient safety and appropriate use of such devices. To name only some of the safety standards completely disregarded by the Oxford Center staff on this tragic day were the daily maintenance check was not performed, the pre-dive safety check was not conducted with the now deceased patient, there was no medical doctor or safety supervisor on the premises at the time of the treatment was not performed by a licensed technician, yearly inspections of the hyperbaric chamber as suggested by the manufacturer were not conducted, and the essential patient-worn grounding strap was not used. To make money as a business, the Oxford Center operated these machines and offered unfounded treatments to patients when medical science contradicted these uses of their services. This was an unscrupulous business operating powerful machines beyond their manufacturer's intended term of use on children's bodies over and over again to provide unaccredited and debunked so-called treatments, chiefly because it brought cash into the door. And as I detailed above, they did so in an egregious, willing, or wanton disregard for life-saving safety measures. Because these treatments were so medically unsound, patient insurance policies would not cover the use of these chambers to treat these conditions. The Oxford Center offered to heal or ease. So this business was a pure cash flow for-profit business. The Oxford Center, and of course, its owner as well, owner Tamala.
I don't think they can prove second degree, but they can prove negligence. And I think this is just me. This is me just going based on basic facts of working past the cumulative of using something past its deadline or past its expiration date, basically. Not performing maintenance as required by the manufacturer, the FDA, certain things. Also using it for off-label use. Although a lot of things are used, like medications have been used off-label because you figure out that it helps multiple things. However, with that being said, the cumulative amount of this is negligent. When you don't perform maintenance that is required by the manufacturer of the device and then someone dies, that's negligence because you knew that you needed to perform maintenance on it and you didn't. They still have to prove that that's the case because this is Michigan. They're corrupt as fuck. I don't necessarily know if I believe half the shit that comes out of Michigan, especially from their governor, attorney general, anybody in state government. With that being said, taking these facts at face value, if half of this is true, they are effed. So much negligence. I thought they actually lied about the hours, not just ignored the manufacturer's recommendations. They might have done both, one, the other. We'll have to wait till stuff comes out. This is a year old. This happened last March. So this is just over a year old. There is no actual trial date that's been released to the public yet. So it's, I do not like that state up north. Being from Wisconsin, I don't like being from Wisconsin, and having lived in Ohio as a kid, I don't like them either. But knowing how their governor handled between the years of 2020 and 2023, I don't like them either. So it's all on the wall cord, written proof of safety and machine. Look, next time you're near a plug and O2, it's obvious it should be. It's just the crime happened last January. I knew it was I thought it was February, but whatever. Either way, it's a tragedy that, from the sounds of it, never should have happened.
Peterson. Thomas Cooper, at just 5 years of age, died in an easily preventable tragedy occurring inside an unsafely operated medical device beyond its intended service years after a treatment not supported by medical science to treat the ailments from which he suffered at a facility that offered these services and managed these devices in defiance of international safety standards in accordance with whatever would provide them the most income or profit. Tamala Peterson, the owner of the Oxford Center, was arrested yesterday near her home and will be arraigned later today on one count of second-degree murder. Gary Markin, a primary manager of the Oxford Center, was arrested yesterday at his home and will be arraigned later today on one count of second-degree murder. Jeffrey Mosteller, the safety manager of the Oxford Center, was arrested yesterday in a traffic stop near his home and will be arraigned later today on one count of second-degree murder. And Alita Moffett, the operator of the hyperbaric chamber on the day of Thomas Cooper's death at the Oxford Center, was arrested yesterday at her home and will be arraigned later today on one count of involuntary manslaughter and one count of intentionally placing false information on a medical record as a medical provider. All defendants are currently housed at the Troy Police Lockup Facility, and each will likely be transferred to the Oakland County Jail following arraignment. Arraignments for each will take place before Magistrate Chiapelli in the 52-4 District Court in Troy. And I'd like to express my sincerest condolences to the Cooper family and my utmost appreciation to the officers of the Troy Police Department. This investigation I know was extremely difficult and had a tremendous impact on the Troy and Royal Oak communities. We thank you for your care and your great diligence on this matter. And with that, I will now take any questions you might have.
Thank you so much. If you have a question, please raise your hand and I'll call on you. First, we have Dustin McCrane.
And this was at 1.25 speed, so her eye movements did look a little erratic, like she was on something. Even though her forehead didn't move because of her, what I would assume is a lot of Botox. This is sped up, so just bear with me. But yes, gross negligence, definitely gross negligence if these facts are true. Right now, taking these facts as true, we have a huge issue. Huge issue. I think some of the things might be overcharged. Once again, not a lawyer, especially not a lawyer in Michigan. Y'all know one. You can ask him what he thinks. Tell him I sent you. However, this might be hard to prove the second degree. However, you know, I'm all about Botox. So of course I noticed I am trying to eliminate my need for Botox. Thank you, Stringer Bell. You're awesome. So before we get back into it, this is what I've been using on my face to try to get rid of the forehead wrinkles. And so far, so good. I've been putting this on my face instead of chemicals that could be endocrine disruptors. If y'all are interested in trying this, I'm not telling you to go do it, but if you want to try it, go to their website, thetellthetruth.com. Beef tallow, chef's kiss. Use code SQUID and you get 15% off every order. So, yeah, the company put profits and protection over protection and safety. Yeah, it's yeah. Lori, I know. See, doctored records. Gee, like I didn't know they did that. Yeah, I seriously think you should find a lawyer, but that's just my personal opinion. I despise this AG, but she's not wrong. A whole lot of things were not on the up and up. I agree. It does not smell like steak. It smells like honey and frankincense and a little bit of that tallowy smell. But it's so good. It's so good. Shouldn't that piece of equipment have a maintenance logbook with an X? You would think. Question, what went wrong? Everything went wrong. Safeguards that are supposed to be there were ignored. It's like the Swiss cheese model. But negligence, remember, to prove negligence only takes one time. Just saying. Hey, Harry, how are you? You're welcome.
Dustin, if you can unmute yourself.
Thanks, I appreciate it. We sort of knew that this was going on for a few years. Had your office been aware of the Oxford Center in previous years or done any investigations? Because we know that they had complaints for other reasons, not to necessarily do with Hyperbaric chambers, but had it been raised and had you been aware of this in the past?
So there had been ongoing investigations, but that dealt more with the issue of fraud than it did the safety of the hyperbaric chamber. So that had not been an issue that we were aware of or had investigated. But there were other issues dealing with, again, issues related to fraud that were where we had ongoing investigations, and of course, previous convictions as well.
Thank you. Next I have Randy. Randy, what outlet are you with?
Channel 7, WXYZ TV. Thank you for the opportunity. A quick question for Attorney General Dana Nessel. These hyperbaric chambers often have fire suppression systems built into them so that if there is any sort of spark, it's immediately extinguished, et cetera, et cetera. Did the hyperbaric chamber in question have a fire suppression system installed and in working order?
So I think I'm going to allow my Criminal Bureau Chief, Daniel Hegman Clark, to answer that question. Danielle?
We do not believe that it had a fire suppression system on it.
That's an interesting
Thank you.
conundrum.
Next, we have Kristen Shamus. Kristen?
Hi, it's Kristen Shamus from the Detroit Free Press. I'm wondering if you can tell us whether there are any state, federal, or local oversight of hyperbaric oxygen chambers in Michigan. And is the Attorney General's office reviewing all facilities in the state that use this type of therapy now?
Right. So my understanding is that US FDA regulates both the oxygen used in HBOT and in hyperbaric chambers. And then an organization called the Undersea and Hyperbaric Medical Society offers accreditation for centers who meet or exceed these standards. And then LARA is responsible for overseeing the license of medical professionals that the Oxford Center employs. And the Oxford Center employs one medical doctor on their staff who was not on site that day. And outside of that, Michigan law doesn't require any oversight over the use of hyperbaric chambers. So without having some sort of probable cause to believe that there are crimes being committed involving hyperbaric chambers in other places in the state, we wouldn't have the authority to go in and perform an inspection. And as we noted, like LARA does not have the capability to do that either because they are not licensed within the state. But with that, I mean, there's certainly advice that we can give to individuals or to families who are considering this kind of treatment that I think is important. So for instance, always exercise caution before engaging in any unapproved therapies. For instance, this one, hyperbaric chambers are not an approved therapy for ADHD, but the Oxford Center boasted over 100 diagnoses that HBOT could help with, while the Undersea and Hyperbaric Medical Society only lists 15. Additionally, the Oxford Center offered training and certification program in which one of our defendants, Mr. Mosteller, provided training to other hyperbaric chambers. And I'd strongly encourage any facility that or the ICHT certification to immediately contact the Undersea and Hyperbaric Medical Society for accreditation and additional training. Also, the FDA recommends that you check with your healthcare provider before using an HBOT device to make sure that you're pursuing what's appropriate care. And if an HBOT is recommended, the FDA encourages you to go to a hospital or facility that has been inspected and is properly accredited by the Undersea and Hyperbaric Medical Society, and the Oxford Center simply was not. So the Michigan Department of Licensing and Regulatory Affairs maintains a free public license verification website for those that are interested. So please, if you're interested in this kind of therapy, take the time to verify claimed licenses and certifications of providers, particularly when those positions involve sensitive work or contact with vulnerable populations. And we know that this is a type of therapy that, while it can be helpful for certain types of medical issues, it has to be used properly. This can be very, very dangerous. We're talking about 100% pure oxygen inside one of these chambers, so very flammable, and it has to be utilized correctly. And obviously, we are alleging that in this set of circumstances, it absolutely was not.
Thank you. Next, we have Elizabeth Chuck. Elizabeth, can you say what outlet you're with, please?
Yes, hi, good morning. Elizabeth here from NBC News. I have two quick questions. The first is, I know that the Oxford Center has a second location. Has that second location been shut down, or is that being investigated as well, given the seriousness of these charges? And then second quick question, are you able to tell us any more details about the allegations of falsified medical records that one defendant is facing?
Danielle, I'm gonna throw this one to you.
Thank you for the question, Elizabeth. As it relates to the Oxford Center in Brighton, it is under investigation. As it relates to the falsification of medical records, I'm sorry, but in order to be able to preserve the integrity of the investigation as well as this case, that information will come out at a preliminary exam.
Thank you.
And that first location is now closed.
Kristen, you had your hand up for a follow-up. Do you not need that anymore?
Well, the question was just about whether the Troy Center and the Brighton Center were continuing to operate or whether they've been shut down.
Perfect. Okay, last chance for last questions. Okay, seeing no more. Oh, Sarah Wright, what outlet are you with, please?
I am with the Troy Times. I just was wondering, with the state of these machines, as you said, many of them were not being safety checked in a way, would they have any effect on other patients that were using them? Like, would there be any negative impacts as they were used and they were not being maintained as well as they could be?
Yep, that's the basis of our allegation here, is that because they were not maintained properly, that those defendants involved should have known that there, was a chance, a reasonable chance that we would see this kind of outcome. So that really forms the basis of our allegations.
But would this affect other, do you think this would have effects on other patients? Like, could other patients like seek litigation because of this potential safety concerns?
Well, I think you would have to have some sort of harm come to you, right? And so because this was an instance, obviously, where a death resulted.
Kristen with the Free Press.
Thanks. I'm curious about whether there's any information you can share with us about how that initial spark was ignited in the hyperbaric chamber that killed Thomas Cooper.
We know how it happened, but Danielle, do you think it's appropriate at this time for us to answer that question? Or do you think we should wait for that to come out at the preliminary exam?
I think it's appropriate for it to be further addressed at the preliminary exam.
Okay. Yeah, there'll be a detailed explanation of exactly how that happened, and we know how it happened. But that'll be discussed later during the exam.
So this hasn't gone to trial yet. There is no trial date set.
If anyone has a question as the day continues, please email agpress@mi.gov. And thank you all for your time today.
Thanks, everyone.
Ooh. All right. So we're going to stop sharing that for just a second. And Harry, thank you for the $5 super chat. Nutella Rain, welcome. She will be so happy. Because every morning it's telltale toast, telltale toast. Yeah, family filed 100 million civil suit. It's bad. So we do have the full hearing of the CEO who was charged. There has not been a whole lot out on this case. However, he was there for ADHD. And they are closed. They are no longer open for good reason. However, if you go to Chamber of Commerce and you look them up, this is what you will find. So you will find things such as this. If I could give 0 stars, I would. This place is a money-making machine run by a cold-hearted CEO. Be it, this was March 9th of 2024. This incident happened January 31st of 2025. Flash fan, that's why I thought it was February, is because it happened on the last day, so everything subsequently in the investigation was in February. That's what got me confused. I thought the chamber promoted stem cells. Well, I do have what it's FDA approved for, what it is not. It's off-label use for things. You have to be careful. You have to be very, very careful. And this is where ethics come in. And we talked a lot yesterday on the other channel about ethics and staying in your lane and admitting when something is not right. Here is part of this. This place is a money-making machine run by a cold-hearted CEO who doesn't care about sick disabled people and only cares about her pocket. Beware. I have seen disabled kids unattended and mistreated. Kid was crawling inside the oxygen chamber, licking the door while the supervisor was busy on her phone. Very sad scene. They treated me and my daughter very disrespectfully after I told them I wanted to cancel our future appointments. I went there to get oxygen therapy for my daughter for a scar that wasn't healing well. Please take your kids elsewhere. It's sad how they treat sick and disabled kids. They are using insurance companies to collect money off disabled and sick people. So sad, so sickening. They bend the rules whenever they want, have no respect for people they treat. And yes, I reached out to management and the CEO, but they don't care. They only care about their bottom line. So that was yeah. You have a lot of positive reviews, but you have negative reviews too. So just remember when you're covering things or when you see something, take it with a grain of salt, because a lot of people write things when they're pissed off. But also certain things cannot be discounted. So this is the hearing, and we'll kind of skip through this because it is 24 minutes and I don't plan on taking all 24 minutes. However, and I do have it on 1.25 speed, so we'll yes, your front desk people must be nice. If your front desk and your receptionists and your like your CNAs or your medical assistants are rude, doesn't matter how good your doctors, your nurses, or your treatment procedures are, it's from the top down. Like, everybody has an impact. It's so bad. Lurking and working.
I'm now going to 5000876, the people of the state of Michigan versus Tamla Peterson.
Thank you. Good morning, Your Honor. Assistant Attorney General Chris Kessel for the people. Good morning, Your Honor. Joe Gleason on behalf of Tamla Peterson, who's seated to my left.
Thank you. Could you stand and state your name?
Tamla Peterson.
Thank you. Are you still using the same address that I have here in the board file? Yes. Thank you. Today is the date and time they had scheduled motion that was filed on behalf of the defendants. It was a motion requesting an evidentiary hearing to determine the extent of law enforcement's access and review of privileged materials. I've obviously reviewed the motion. We had a response that came in last week. So where do we stand?
Your Honor, I may just add a couple brief comments in addition to the motion, because obviously the reports that were attached were not available at the time I filed the motion.
Of course.
Thank you.
I'm not judging, but I'm judging.
Your Honor, what I'm asking for,
Not
and I know the
the
court is
word
aware
for
of it, is an evidentiary hearing to determine what the police looked at when they examined the computers and telephone of Ms. Peterson. At the time I filed my motion, I was aware that the detectives from the Troy Police Department had done an investigation because they told the magistrate when they did the swear-to and the bond hearing that they had revealed, and I believe the Attorney General made some comments as well, that they had located information that they used to persuade the magistrate, among other things, to set a very high bond. There were a very limited amount of reports at the time indicating that at least they had looked at things, but not the nature of the searches, how they had located them, anything that really documented the searching that went on. Ms. Peterson had attorneys prior to February, I believe, 5th, when the items were seized. They had been longstanding attorneys. I notified the Troy Police Department when the items were seized, saying, look, we're the lawyers. You shouldn't look at our attorney-client privileged materials. And at least at the time of the filing of my motion, there were not the reports that the court received from the Attorney General. And that causes me some concern, because these reports are generated 6 months after the searches took place. These reports are dated July and late June of this year, when the searching apparently occurred in February. And I'm not sure why these reports are being generated now when they should have been generated at the time the searches were made. And even so, what's been given to the court and to me in these reports is fairly, I would say, lukewarm at best. They don't identify, especially when I see a Detective Mork's report, what items he looked at specifically, what searches he used, i.e. how he framed his searches, whether in fact he actually looked at the 75 records that he bookmarked as communications between Ms. Peterson and a member of the Varnum firm. And so these appear to be kind of stopgap reports that are of a very general nature as to what exactly occurred. Now, I don't know what occurred. I have not been provided any detail about the searching, but I'm extremely concerned that this was withheld from us in February or March. And Mr. Kessel, to his credit, I said, Mr. Kessel, where are these reports that generated this information that you used at the bond hearing and that Detective Trigger mentioned at the swear-to? And the first thing I get back is an email saying, well, 8 detectives from the Troy Police Department examined these devices. I didn't know that, because the materials I got originally from the Troy Police Department didn't talk about 8 detectives looking at forensic examinations of electronic devices. Then, after being told that these detectives look at this, I get these reports generated 6 months later. And I'm concerned, and I'm asking now for the evidentiary hearing to determine why these reports are being generated now, why not at the time the searches were made, and for further detail as to what exactly they did. And that's what I'm asking for, Your Honor. I didn't have these reports when I filed my motion, and I think this is right for the court's investigation to determine what they looked at and why they concealed that from us in the 6 months that we've been here before you. Obviously, this is information that the Attorney General may offer at the time of the preliminary examination, and 6 months go by and we don't know that this had gone on, and I'm concerned about it. So those are my additional remarks. I thank the court for allowing me to make them.
Go ahead.
Thank you, Judge.
I mean, I can already tell that I don't like this chick. I can already tell that I'm going to be biased if this trial is streamed. I can tell you that I can tell you that I will probably not go into this without a level of what the actual F are you doing? However, her lawyer had a point.
Your Honor, I guess first and foremost, I think what Mr. Gleason is asking for is what even first-year law students would recognize is a fishing expedition, right? He's asking for a hearing on the off chance that something might be discovered, because the truth is he cannot point to any evidence that has been used or referenced or anything like that that would indicate that any of his clients' attorney-client privilege communications have been breached or broken into or anything like that. The simple answer as to why it took so long for these reports to be generated is because for several months, members of my department had been going back and forth with Mr. Gleason and members of Varnum about the approval of our review team policy. And because they wanted to fight us on that, it took this court stepping in to approve that policy and make it, the rule of law in this case. And as soon as this court ordered that policy would be put in place, I immediately got with Detective Trigger, said whoever was involved in these searches needs to write a report in accordance with our policy. And that's what they did. And as soon as they got those reports to me, I got those over to Mr. Gleason. He's certainly correct. He asked who has been involved in examining these devices. And of course, I immediately told him exactly everybody that I knew had been involved in these searches. It's certainly easy for him to say these things have been concealed. But again, Judge, Mr. Gleason can't have it both ways. He can't say for months, we think your review team is inadequate and it can't be used. And then months later say, well, your review team should have been being used back then, and why wasn't it? And there's concealment. There's been none of that, Judge. I would indicate that these devices were seized, and Detective Trigger, as is noted in the attachment, was in contact with Ms. Peterson's attorneys. And Ms. Peterson's attorneys never said, do not search any of these devices because they contain privileged material. What it says is, when you look through these devices, please be aware that there may be privileged material and take care not to look at that. And everything that I have seen, and even everything Mr. Gleason has seen, though he might not want to admit it, indicates that that is what was done. There were items that were recognized as privileged. Those items were set aside because that's how the Troy PD does things, and that's how we would want things to be done. The Troy PD is not some police department that has never dealt with potentially privileged material on electronic devices. They know what they're doing, and there's nothing that anybody can point to suggest they've done otherwise. So, Judge, we're objecting to the evidentiary hearing. It is a classic fishing expedition. Not only has there been any impropriety, but even Mr. Gleason has to admit there's not even the appearance of impropriety. There's just the hope that some might be discovered, and that's not what evidentiary hearings are for.
Okay. It's your motion, so did you want to have the last word?
I always like the last word, Your Honor.
Actually, I'll give the last word.
You get the final word, Your Honor. It's a slate.
I would not. Even if you're trying to make a joke, this judge is not someone that I'd fuck around and find out with. She doesn't seem like the type to. She does not seem like the type to want to joke when dealing with this case. Yes, this woman right here is the CEO. The woman that was in the gallery sitting back behind this lawyer, I don't know who that is. So, it's got to be extensions. And I got her in a really bad freeze frame, which, she's soft-spoken though. Yeah.
I disagree with Mr. Kessel that I somehow put a pause on anything. When a police officer does an investigation, they're supposed to write a report. They didn't, and they didn't for some reason. And it's nothing's in here says Mr. Kessel told us not to do it, not to write a report. They simply didn't write the reports. That's not a function of my complaint about a tainting. That's a function of a breakdown at the Detroit Police Department as to why 8 or 9 detectives didn't write reports when they examined these electronic devices. And that's the appearance of impropriety. When you have 6 months later, oh yeah, we did this general review. We're not going to tell you what our search terms are. We're not going to tell you how we did it. And in Detective Mork's case, not state explicitly, I did not review privileged materials. Thank you.
Okay. Well, I've had a chance to review, obviously, the motion, which essentially is just seeking the court's approval for an evidentiary hearing at this point. And the people filed a response, and they attached a number of reports that we've discussed on the record today. that appeared to cover each one of the detectives that was involved in investigating this matter. I read the cases that were also cited. You didn't really refer to them here when you're arguing on the record today, but of course I took the time to read both of them. One of them is published, one of them is unpublished. The published opinion and the unpublished opinion cite back, of course, to U.S. Supreme Court decision that the court has to take into consideration. I also reviewed every word of the transcript that was provided, looking for some information, even though it wasn't very clear or clearly articulated in the defendant's motion about what specific information there is cause to be concerned about that I could consider may or may not have been utilized by the detectives and may or may not have been in the context of privileged communication. And that's the support that I'm looking for to side with the defense in their request for an evidentiary hearing. Everything that I reviewed, every case, every opinion, really indicated that the defendant would have to make a prima facie case, that there's some specific information that was utilized in the course of the investigation that then ultimately led to support probable cause to arrest, the charges that were authorized by the state, that was a violation of Ms. Peterson's privilege rights. And there was nothing specific that the defense presented, nothing that I could see in the transcript that was provided. And to be very honest, it was only 2 points within that transcript on page 17 and page 19, where there was even reference to a review of the materials or the devices that were seized, specifically the phones and the computers. In those 2 points in the transcript, there's nothing specific. There's some talk about photos, CCTV footage that outlined what was able to be viewed within the office or within the location in which the incident was alleged to have occurred. Messages that were allegedly taking place between Ms. Peterson and her staff. There was also reference on page 19, but I found that information to be more in line with information that was put forth to support a bond request. Nothing in here that outright gave the court any indication that this information that was cited came from these privileged communications between Ms. Peterson and her attorneys. So that's the issue that I'm really struggling with to get us to that point where I would be able to support and grant the motion seeking an evidentiary hearing. Without that, really what would happen if I approved it is an opportunity for us to bring in each one of the detectives that had some role in the investigation and question them ad nauseum about information just to see what they would testify to. The reports that were provided and attached to the plaintiff's response, you're saying, why now? I felt like you had requested this information. So the expectation that you seem to be placing on the detectives to write a report confirming an action, I don't know that we would have otherwise expected all of those reports to be submitted on February 5th, because at that point it appears there was very clear communication that came from Ms. Peterson's civil lawyers to the police department, putting them on notice that there was or would be potentially privileged communication on the devices that were seized, and then representations which no one refuted that Detective Trigger reached out in response to confirm receipt and to indicate that the appropriate safeguards would be taken. So I don't know that I would share the position that's being taken at this time that everyone should have jumped on board at that moment to write a report confirming no action that was taken. My understanding of the request that was being made by Ms. Peterson when the motion was filed was specifically to the state. We want to know who potentially investigated, who potentially had access to these devices, and what, if anything, they saw. And as a result, the reports were generated. If there
Is anybody still triggered by the words, what if anything, from Elaine? I mean, that goes all the way 3 years ago to Johnny Depp, but like, I'm still triggered by the phrase, what if anything? When a lawyer or a judge says, what if anything? My brain wants to explode.
there was anything that I could see in here, again, that could potentially make that argument that there's prima facie evidence being presented, that there was some sort of use of privileged communication that would have been a violation of Ms. Peterson's rights, I would gladly grant the request for an evidentiary hearing. But without that, I really do somewhat feel as though I would be buying the tickets for all of us to go on this fishing expedition. If you had anything else that you wanted to present to the court, I fully was prepared for you to come in today. But just relying on the transcript, which I read every word of it, there was nothing in there that was identified in any way, shape, or form as information that could have only come from a review of privileged communication, and nothing else was put forth. The information that was provided by each of the detectives in their written statements, some of them indicated they didn't even have the technological access to review anything. Others indicated that to the extent that they reviewed anything, there was nothing that contained communication from an attorney. There was some games, photos, documents, things that may have had evidentiary value, but nothing that came from communication between Ms. Peterson and her attorneys. There was a statement provided by Detective Mork. I think the outcome there was some review that was undertaken. There was a process to bookmark information that should not be reviewed. But ultimately, when they were informed that they could not continue until there was a D team or other protective measure in place, he didn't even issue a report. So clearly nothing that would have been disseminated to be relied upon for purposes of the investigation. So I think based on everything that I have in front of me today, I wouldn't be able to grant the motion because I simply can't find any specific allegation or specific information that has been put forward to the court that would lead me to believe that there's a basis to conduct the evidentiary hearing. And if I've missed something, I'm happy for you to tell me that I've missed something. But just in general, the reports that have come at this point in time, I found them to be in response to the motion. I also found the timeline that the state has articulated to be in line with the reports. Clearly, this is a situation where, although I think Ms. Peterson alleges in her motion that the state may have failed to act and there was some lengthy period of time where they didn't do anything to protect her confidential or privileged communication, I would disagree because the timeline that I've been provided shows that the day of or the day after the search was effectuated, her civil lawyers put everybody on notice about what could potentially be on those devices. Protective measures seem to have been taken by the police even before the state was involved in the case. And since the time that the state's been involved, which I think they cited the earliest date being mid-March, although I would imagine that they were involved in some capacity before that, it sounds like they had been working through creating the formal process of putting together a team and trying to reach an agreement. And we all know because of the last court appearance, there was some discrepancy on how to do that, but ultimately that's been resolved. And from what I understand, the parties have been able to work through those issues. And I anticipate that discovery is going along in the way that it needs to. So I don't see that there's any evidence that the state unduly delayed action. The timeline that's been presented to me doesn't cause me concern that the police were left to their own devices with no oversight or supervision and that we don't have the appropriate information at this point to believe, at least where we stand, that the evidence that they relied upon, they gathered through other sources. So I don't know that we can even get past that first step of that analysis as to whether or not that evidence should be suppressed, because there was really nothing cited specifically that is causing me concern based on where we sit today.
Your Honor, I simply ask for the opportunity, perhaps when we have the preliminary examination, to ask a few questions in that regard. I think that would be the appropriate time, given what I have. So.
I think that is fine, actually. Again, I don't want it to turn into something where it becomes a fishing expedition in that manner, but I anticipate at the exam that these witnesses will be called, and they're going to be asked about the investigation, and they'll be required to answer. They've now put statements together that were submitted and attached to this particular motion and the response that the people filed. And if anything comes to light that causes you some concern, or it appears that they may or should be cross-examined as to the statements that they've made prior to the exam and at the exam, I will certainly allow that.
Thank you very much.
Anything else that we need to address today?
Judge, other than I think Mr. Gleason and I were talking earlier, speaking of the Tate team, I think we're pretty well set on the terms as well, so we won't need any court involvement.
Sure.
There are other cases I have with the Attorney General where they're a little different, but this one I think Mr. Kessel and I are going to get where we need to go.
Okay, that sounds good from our perspective and for your client's perspective. Obviously, the case has been here longer than I would typically have a case pending before the court for examination, but it seems like everyone is making good use of their time, and that when we are together in September, we'll be ready to go, and I'll be very confident that everybody has done what they need to so we can conduct the exam.
Yes, right. We recognize that you would have been available to hold a preliminary exam from the get-go, but the request is ours to be prepared. So I thank the court for the additional time.
Okay, anything else?
May I speak to Mr. Kessel very briefly before you leave the bench?
Of course.
Package, and then to assist with the transition of the building to the buyer. I don't think that would in any way endanger the people or create any risk of flight, which are the primary concerns for mine. And I think Mr. Kessel does not have an objection in that regard.
Yeah, Judge, for that limited purpose, obviously, when a business is sold and, things have to be signed and notarized and that kind of thing. So for this limited purpose, the people would not object to modifying bond for her to get her things out and sign whatever she needs to sign.
Pretrial services would supervise it. She would, again, because she has the tether, would ask permission to go to the location, and pretrial services just needs the permission from the, or the directive from the court to allow that if the court would see fit to do that.
Okay, so I assume every time that we have these discussions, not that it's happening all the time, but we've had a couple of discussions about your client's connection to both businesses, including the one that's in Brighton. I'm just going off the assumption that the parties have resolved any potential preservation of evidence. All of these issues are resolved before I would be asked to agree to modify bond conditions to allow her to do things like sell property, close the business. So I'm relying on my assumption, which I want to place on the record, that all of this has been approved. There's no evidentiary issues, no preservation issues, and that if I give her the ability to physically go to a location to be present so she can close up shop and the business can be sold, this is not in any way going to impact any other agreements or requirements that are put in place on her as far as this case.
Yeah, Judge, I promise if we thought there was any more, physical evidence of evidentiary value, we'd have gone back. I don't think the police have been there in quite some time. So like I said, for this limited purpose, the people aren't going to object to bond being modified on this day for this purpose.
Okay, that's all I wanted to make a record of. That was my assumption, but I want to make sure we put on the record. So did you have a specific date, or you want to just have the
It's going to require a series of days, I think. And so I'm just asking for that. Obviously, once the building is sold, she would have no reason to return there.
Sure.
But we just, and again, all of the documentary or other materials, I won't say evidence, I don't think it's evidence, but
Right.
those will be preserved. We're not throwing anything out. We're just simply getting into storage so the buyer can come in and take over the building.
Sure, I don't have an issue with that as long as she follows the required notice to pretrial services so that they can ensure that she's compliant. I would permit her to deviate from the otherwise do not return to or do not be involved in the day-to-day operations. And I would assume that she's able to do this without the assistance of any of the former employees that would be co-defendants.
I think there's one person there who's a janitorial person, but everybody else, that would be correct.
Okay, I mean, as long as it doesn't impact the others that are proceeding through the court system as
It
well.
would not. It would not.
Okay, not a problem.
Thank you.
I'll grant that, and she can provide notice to pretrial services and they can assist in facilitating. If anything else is needed, just let us know along with Mr. Kessel. We can modify it without you having to come back.
All right. Look at her face. It takes effort to make your mouth turn down like that. Like, that does not happen normally. Like, looking at the camera and looking at myself, that takes a significant amount of effort, and she's been doing it the entire time. Oh my God. How much effort that takes to frown like that. Like, that's not a natural facial structure. Like, it's just not. That took a significant amount of effort. And lady, it is 2026. Fix your eyeliner. This is not 1990 with going all the way. No, get with the times. Redo your stuff. Anyway, sorry, I just have to judge because I don't judge, but I judge. And this is why this is on this channel and not the other one. Just saying. Oh, the new judge is male. See, I understood your autocorrect, Flashan. I got you. Like, so I've been trying to respond on Discord to Heidel because she sent me this is what Heidel sent me. So HBO for ADHD. Yeah. Okay. So here's my issue. And this is my thing of like when you're evaluating anything, when you're evaluating a healthcare facility, when you're evaluating cosmetics, anything. So this is an article written by Valley Health and Hyperbarics. So they are going to give you what they want you to hear. And there has been a 2015 study published in Medical Gas Research explored the effects of HBO on children with ADHD, finding improvements in attention span. I can't actually find that study. I haven't looked very long, but I went to PubMed and I looked for that study and I could not find it easily. I'll have to go in more you know, a 30-second search is a 30-second search on PubMed sometimes doesn't get you a lot. So take my I couldn't find this study with a grain of salt. I might have typed in the wrong wording, whatever. However, I did go to ChatGPT and I said, find peer-reviewed articles on the efficacy of hyperbaric oxygen therapy and ADHD in children. This was its response. I dug through the literature and here's the honest, and I'm gonna get rid of this. Here's the honest state of the evidence. There are a few peer-reviewed studies specifically looking at hyperbaric oxygen therapy for ADHD in children. Most of the claims you see online are extrapolated from concussions, TBI studies, autism studies, or small uncontrolled cognitive function studies. Right now, there is not strong evidence supporting HBO as an evidence-based treatment for pediatric ADHD. Here are the most relevant peer-reviewed papers and reviews that I found. Direct, indirect ADHD-related evidence, small attention cognitive studies, not true ADHD RCTs, improvement of attention span and reaction time with mild treatment in 2010, looked at attention measures after HBO, but it was a small sample, not pediatric ADHD specific, not a strong clinical trial design. So when people, this is where I get very selective and scrutinized, because anybody can turn, it's like a headline in a newspaper. Anybody can turn anything into, well, this looks good for us. But if you actually dig into the research, which I have not done yet, so I cannot speak with an informed opinion. However, when I hear about a study or I read an article that is written by someone promoting their business, I get very skeptical straight off the bat. So, and you have to look at what these strong clinical trial designs, because anybody can run a study and skew the results. And we did talk about that on the other channel a couple weeks ago of skewed results and how to skew data based on what you're looking for. And there's interpretation of everything. So it's just, we take it with a grain of salt. We take it with a grain of salt because there's not. However, I do know a pediatrician who specializes in autism. And when I see her next week, I might ask her a question on her opinion of this. And the pediatric post-concussion syndrome trial, a 2022 randomized control trial, found cognitive and behavioral improvements in children with post-concussion symptoms after HBO therapy. Important distinction, these were children with brain injury / post-concussion syndrome that does not automatically generalize to ADHD. But HBO marketers often use this type of research to imply a broader focus or executive function benefits. Autism literature frequently crossed over into ADHD claims. A 2012 systematic review concluded the evidence for HBO therapy in autism was controversial and weak and inconsistent. 2017, a Canadian family physician review, randomized trials, no evidence supporting benefit of children with autism. 2021 review in Brain Sciences. Let me see if this is the same one nope, brain injury. Highlighted, none of the literature reviews showed HBO to be clearly effective for ASD. That matters because ADHD clinics sometimes market HBO under the broader umbrella of neurodevelopmental optimization, even though the evidence base is already shaky in the condition most studied. So you have to take things with a grain of salt. With that being said, I do have the list of what it is approved for, what it is claimed for, and then the FDA safety warnings on it. I'm skeptical, but I've got ADHD. I don't have ADHD, although I've been tested for ADHD multiple times. And I think that they screwed up. I seriously think I'm ADHD. But, all right. So we have this one. Like this is where the evidence is the strongest and where the FDA actually recognizes this as a therapy. Decompression sickness, carbon monoxide poisoning, which totally makes sense because decompression sickness is a pressure issue. So oxygen logically can help. Carbon monoxide poisoning, obviously. So carbon monoxide replaces the oxygen in your bloodstream. So trying to get oxygen back into your body and get the carbon monoxide out, hyperbaric totally makes sense. Diabetic wounds, this is where I get skeptical because I had a shit ton of patients over 6 years with diabetic wounds. Did it help? Jury's still out. Did it hurt? No. I don't know. I don't hate HBO therapy. However, take it with a grain of salt because working with these patients for weeks, sometimes weeks or months at a time, or seeing them come in and out, in and out, in and out, I saw more people lose toes, feet because of wounds than I saw actually improve, although they were going to HBO. So how much was it really helping? The research says one thing, clinical observation, just my observation based on working with multiple people with diabetic wounds. I have seen the inside of more people's toes than I want to admit. However, severe burns supports healing in severe burn injuries and reduces tissue damage. Radiation helps treat tissue caused by radiation therapy. Some of those totally make sense. The burns, I have also seen smoke inhalation be a cause for receiving emergency HBO treatment. Obviously trying to get oxygen back into the lungs and get the smoke out. Totally makes sense to me. How hyperbaric should be kept for the bends because the option B is unalived. Hey, Chucky, how are you? Good to see you. I don't think you fit their standard tests. That's true. Yeah. Oh, if you like this slide, just wait. I got two more. Yeah, two more. I put my work in today. Although I'm not gonna lie, ChatGPT helped me make these because I am not skilled enough with Canva to do this on my own. So I tell, here's the list of FDA approved stuff. Make me a graphic. So I will admit that ChatGPT helped me with this because I can't make nothing look that good without some help. Maybe Rosalind could help me make it look that good, but my skills alone, not happening. All right, off-label and wellness claims. This is where it gets a little questionable. And yes, some things do work off-label, especially some medications. You will see one medication used for depression, and you will notice that migraines go away. One medication will be used for, there's a medication, I can't remember the name of it right now, but it is used for rheumatoid arthritis. But they noticed that people's psoriasis went away. You will notice things have side effects that end up being a helping versus hurting kind of an issue. However, yeah, out of all the the AIs that people are trying to use. I know people go to Grok and ask Grok questions and for Grok's opinion on some stuff. I just stick to the oldie but a goodie, ChatGPT. ChatGPT helped me come up with my calendar of how I'm going to do stuff, like ChatGPT. It's my personal assistant. So, well, yes. So what I do is I say, hey, provide me the links. So when I say look for peer-reviewed research, I have it automatically put in that it will provide me with the links that it is using to get its information. And then I go through and I'm like, hey, this link is wrong, fix it. Like, your link does not match the study you showed me, fix it. And it will. So it's trust but verify. And you always verify. But it also found me 5 articles faster than I could go to PubMed. In the same amount of time that I went to PubMed and I searched for ADHD and hyperbaric, it gave me 1, 2, 3, 4, 5, 6 links that I could check out. So, yes, it might be incorrect for some things, but it is very, very helpful for others, such as cutting down the amount of time that I spend researching to find a list of 10 articles, because I will look for it. I will find me 10 articles on human movement and pain. And I will say it's for this and this and this topics, and narrow it down. And sometimes it'll provide me with good links and sometimes it won't. But I always make sure that it gives me the links so that I can do the research on my own. However, it is so much faster than going to PubMed and trying to do a search for keywords and getting 100 results back. And having to click on each one and read the abstract. It's so much more helpful. The long beer flu. Yeah. So, yeah, Ammo's girl is really good at that stuff. So I know it's not always right, but it helps me research stuff when I don't have the time to sit on PubMed for hours at a time. So, plus it's interesting to see its opinion on stuff. So, it is interesting. For these, I gave it the FDA's website with a letter. Where did I put that letter? I gave it to make these graphics, I gave it the letter from the FDA about safety. I gave it basically the FDA's website that it said what it's FDA approved for. And I also gave it the Undersea and Hyperbaric Medical Society. So I gave it specific links from all of those and had it make these graphics for me. So yeah, for athletic recovery, I think cryotherapy works. Yeah, and the jury's still out on whether people like that. And there's been supposed research, I have not seen it for myself, about how that messes with women's hormones. It's great for men, not great for women. However, I personally love it. Yeah, using it as a tool, no problem. Agree, cut down. I was just talking about blanket trust. Yeah. I don't trust people. Why would I trust a computer? Yeah. It does cut down on research time significantly. So off-label and wellness claims, this is where marketing, and I've been watching a few YouTube videos on like other things lately. There has been a creator, I cannot remember his name, but he's Welsh. He has a twin. One does makeup, one does skincare. He was talking about Medicube, how Medicube was banned from advertising in Korea for a certain period of time because their advertisements made it sound like they were a medical treatment instead of skincare. So a lot of this is maybe not the fact that the research isn't there, It's how you twist words into making it seem like it's better than it is. So autism, limited and inconsistent, Alzheimer's, limited and inconsistent. That's not to say that it's not there. It's just, it's inconsistent. And that goes to what studies were being used. Were they large samples? Were they over many years? Was it 20 people? Was it severe a disorder? Was it ADHD that's minimal, fully functioning, or was it ADHD that is like I'm having problems interacting with my daily environment? TBI, limited and inconsistent, all of this is limited. So the left side is inconsistent and limited. The right side is preliminary. So it's on it cutting down research time. My fears will miss nuance sometimes because someone didn't read a paper and make a connection that AI could. No, I say give me 5 articles. I read those articles on my own. That's what sometimes takes forever, is because I'm a slow reader. However, it finds the articles for me, because if you've ever looked at PubMed, this is what PubMed looks like. So when you type in, this is what, when you type in something on PubMed, so like this is what you'll get, and you'll just get this, and like I will get like ADHD children, and you will get just this. It's like a Google search, page 1 of 166, and it's like non so like non-pharmacological interventions in ADHD. And I filters applied in the last year, free full text. So you do this, and like you are looking through all of these, and you are trying to read the background and the abstract to see if it applies to you. But it takes forever, especially if you're a slow as shit reader like I am. So it helps to find articles that may be more, when it knows what I'm trying to find. Hey, I'm looking for articles related to ADHD and hyperbaric. So it will do keyword searches, and if it notices hyperbaric in an article, it will send me it. Whether it's appropriate or not, it's better than trying to search through 55 pages to find one article. So, yeah. Sometimes I have to read it like 3 or 4 times. I'll put a PDF into Speechify after I try to read it and have it read to me while I'm doing something else, because sometimes I'll catch things on the 2nd, 3rd, or 4th read that I didn't catch on the first try, which is, yeah. Yeah. I think both, but I also, I have thoughts, but so going back to this one, this is what the research needs more time. So it's not saying that they don't help, but it's also the way that things are marketed, because marketing is everything. And are these businesses marketing in a way that tells you research is limited, or are they researching or marketing in a way that tells you this will help you? There is the difference, because if you look at this, let's go share this. So this one never says anything about this thing never says anything about what the research is limited. Like it says, although research for ADHD is developing, preliminary studies and anecdotal studies are encouraging. That one sentence in this entire thing is all where it says that, it's just, it just because it says that it can help doesn't mean that it will. And it's also going back to when you read something, how is it marketed to you? Are you getting both sides of the story? I don't necessarily know. And when you are getting this therapy, who is doing the therapy? Are you getting this therapy under the care of a doctor or a nurse practitioner or a PA? Somebody with a high level of education, not just a tech. Yes, a tech has an education. I'm not saying they're stupid. What I'm saying is someone who can look at the big picture and has all the pieces to the puzzle, not just this one piece. And it's a complicated situation. But here is where I think that will be the biggest issue going into this trial. So these are safety warnings directly from the FDA. There's a letter that was written by the FDA about safety communications after reports of fire, serious injury, and death associated with HBO. FYI, this letter that I'm referring to and the safety report was after this incident. I could not find anything like letter form from before. I don't know if this particular web page was updated and just updated to August of 2025. And it had other things before it was updated. I don't know. I will have to go in the Wayback Machine and look. I have not gone to the archives to check because 3D world. So just putting it out there, devil's advocate, where I've got this information from was put out August 25th of 2025, or August 20 something 2025. So fire risk, high oxygen, heat, sparks, static electricity, or flammable materials can cause catastrophic fires. There's problem one. The child was not grounded properly. AI has read every medical journal ever, and it knows that it has biases based on what's written. Yeah, but so do we. And that's also why you can go to more than one AI program, because they're all written differently. Follow protocols, manufacturer's instructions, facility safety plans, and industry standards every time. Proper training and equipment requires trained staff, regular maintenance, and appropriate certified equipment. Not risk-free, barotrauma, oxygen toxicity, seizures, and lung effects are possible. Yeah, oxygen toxicity is real. Second, technically speaking, you can drown from the inside out. You can drown yourself drinking too much water too fast. So it's a real possibility. When I was on ABVD chemo, I was told not to get oxygen. It's one of the reasons that this needs to be done by people who are trained, because every good thing does have downsides. Not everything is going to go according to plan. And this is one of those situations where not everything is going to go according to plan. But we are pretty much done for the day. This will be an interesting case. I don't know if I will be able to be biased or non-biased in this case. I have a feeling I will be completely biased One, because it's a child, an innocent child. Secondly, if what the state is alleging is even half true, there was a lot of systemic failures here, starting from the top down. There's no other way of putting it. If what is being alleged is true, there's some huge issues here. All right. Oh, on that happy note, I am going to open this packet of yogurt for the little. I am also going to redirect us over to the Slightly Buzzed show with Nick Starr of Trial Watch. I will be hopping over there in about a half an hour, talking Karen Reed and the new things in the Karen Reed case. Y'all have a great rest of your day. I will see you Sunday night at 9 p.m. on Evidence Through Motion for another movement related video, this time talking about the movements that we lose first. All right. No one fed me. I had string cheese and some elements. That's my lunch. I'm about to go eat because I'm hungry. Y'all have a great rest of your day, and I'll see you over on Nick's channel. Bye, guys.